Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
We are diving deep today into a single, complex civil action. We have a whole stack of legal documents here detailing a workplace discrimination and retaliation lawsuit.
Yeah, this one was filed in the Eastern District of New York.
The case is Melissa Garcia v. Westhampton Primary Care, Staffco of Brooklyn, LLC, Maria Barlow, and Maria Alessi. And it really provides a forensic look at how years of alleged hostility, managerial neglect, and just outright supervisory sabotage can come together into one powerful legal claim.
That's absolutely right. And our mission in this deep dive is really to synthesize three very distinct perspectives that you find in these documents.
Okay, so what are they?
First, you have the plaintiff's specific chronological allegations. They're incredibly detailed. Second, you get the defendant's comprehensive denials, and some of those include some really powerful jurisdictional defenses.
Right.
And then finally, we have the initial legal analysis from the court itself. This is the ruling on which claims were plausible enough to survive the critical motion to dismiss stage.
And we're going to be focusing heavily on how the court evaluated that whole timeline of events.
We have to. The timeline here, I mean, it spans from 2019 all the way to 2023. That timeline is the biggest legal battleground in this entire case.
So let's quickly introduce the principal players, just so we all know who is who in this story.
A good idea.
The plaintiff, Melissa Garcia, is a licensed practical nurse, an LPN. She identifies as mixed race, specifically Hispanic and Black, and she'd been an employee at Westhampton Primary Care since 2016.
And on the other side, the defense side, you've got four parties, but they're really split into two groups.
Group one is the institutional employers. That's Westhampton Primary Care, which is the medical group, the actual place where Garcia worked.
And then you have Staffco of Brooklyn, LLC. They're what's called a professional employer organization, a PEO. Basically, Staffco handles all the HR, the payroll, the benefits.
And the significance of having both of them named in the lawsuit is that the plaintiff is arguing they function as joint employers. So for you, the listener, what does that actually mean?
It's a huge deal. If they're found to be joint employers, it means they share the liability.
Oh, okay.
So even if Staffco is the one handling the official HR paperwork, the hiring and firing, Westhampton Primary Care still controls the day-to-day work environment. They're assigning tasks. They're overseeing the very supervisors who allegedly failed to act.
So they can't just pass the buck.
Exactly. If the court finds they both controlled the terms and conditions of Garcia's employment, then they are both responsible for all of the combined misconduct, both the systemic hostility and the retaliatory actions.
And then we have the two key individual managers, the primary actors in these alleged failures, and the retaliation.
Yes. First is Maria Barlow. She's the office manager and Garcia's direct superior.
And then there's Maria Alessi. She's the offsite manager. And Barlow's superior, the director of ambulatory services.
Right. And just to set the necessary legal context, this action is brought under two main laws. First is Title VII of the Civil Rights Act of 1964, which is the big federal anti-discrimination law.
And the second?
The New York State Human Rights Law, or the NYSHRL. And the NYSHRL is, generally speaking, more protective of employees. It has a broader scope, and critically, it allows for individual employees to be held liable for aiding and abetting discrimination.
And that's a key part of this case against the managers.
It's the only way they can be held liable, really. And procedurally, Garcia did everything right. She filed her initial complaint with the state and the EEOC on October 5, 2022, and then she got her right to sue letter on May 22, 2023.
And you should keep that October 5, 2022 date in your head as we go through this, because it sets a 300-day window for the federal claims.
And that window becomes a huge technical hurdle for some of these allegations.
Okay, so let's jump right into Section 1. The core allegations of a hostile work environment and racial discrimination. These stretch from around 2019 all the way to late 2021.
Right. And the narrative that's presented in the complaint, it argues that this deep-seated culture of racial hostility was there long before Garcia herself became the primary target.
It seems like they're trying to establish a pattern.
They absolutely are. The plaintiff uses these really specific incidents involving other people to establish just how pervasive this environment was. These weren't just, random workplace disputes. They were alleged acts of explicit racial animus that management knew about.
So the earliest incidents alleged, they happened back in 2019 or 2020 and involved a front desk associate named Vanessa Cyphers. And the allegations here are They're explicit and pretty severe.
They are. They demonstrate what the plaintiff claims is a shocking tolerance for hate speech in that workplace.
What are some of the examples?
Well, the documents detail several. Another LPN, Jennifer Crump, allegedly heard Cyphers use a highly offensive racial slur, the N-word, against a colleague.
Wow.
And Cyphers also allegedly referred to the union representative, a woman named Dominique Roberts, as a super black ghetto bitch and a ghetto black version of Tawana Murray.
I mean, those comments aren't just rude. They establish direct, overt racial discrimination. They're tied to these awful race-based stereotypes.
It paints a picture of a workplace where this kind of language was just used openly. And it went further.
How so?
There are two other really striking examples involving Cyphers that show this stereotyping. First, when Jennifer Crump mentioned she didn't like dogs, Cyphers allegedly commented something to the effect of, yeah, black people don't like Dobermans. And second, Cyphers questioned whether the brother of an African-American coworker was in the newspaper for murder. This pattern of behavior is so crucial for the case.
Because it connects race to criminality. It connects race to these offensive stereotypes.
Exactly. This is precisely what a court looks for to prove that racial animus underlies the whole workplace atmosphere.
So if this was happening back in 2019 and 2020, what was management doing? How were they responding?
Well, according to the source material, Jennifer Crump discussed these comments with a secretary manager named Maria Salpetro. And here's a really critical detail that hints at this idea of managerial complicity.
What's that?
Salpetro immediately suggested that complaining to Barlow, the main office manager, would be completely useless. Salpetro allegedly said that Barlow would just throw it under the rug.
That detail is devastating. It suggests the alleged culture of inaction wasn't a secret. The staff knew about it.
Precisely. It creates this inference that management's failure to address harassment was systemic, or at the very least, it was common knowledge throughout the office.
So what did Crump do?
Well, agreeing that Barlow was unlikely to act, she bypassed her and complained directly to upper management instead. And ultimately, Cyphers was terminated.
Okay, so there was some action.
There was, but the document notes it's unknown whether those racist comments were actually the reason she was fired. So this initial response really sets the stage. Managers were aware of severe racial hostility, but there was already this internal skepticism about whether anything effective would be done.
The narrative in the complaint then shifts to the second major perpetrator of hostility, a medical assistant named Sherry Durand.
Right. Durand was hired in late 2020 or early 2021, and the hostility she allegedly displayed went on for nearly a year until October 2021.
And the source material claims Durand, who is Caucasian, was consistently hostile and disrespectful, specifically toward minority coworkers, including Garcia and another employee, Francis Alakwa, who is multiracial.
And this is where the complaint moves from, generalized slurs in the office to very targeted behavior. The alleged conduct wasn't just general rudeness, it was aggressive and intimidating. Aggressively throwing or snatching papers, stomping around the office, muttering comments under her breath. And critically, the complaint alleges she did not treat Caucasian coworkers this way.
Which establishes the racial basis for the differential treatment.
Yeah.
It wasn't just that she had a bad attitude with everyone.
Exactly. It was directed at Garcia and others. This alleged conduct begins to solidify the hostile environment claim as one that's based on their protected class status.
So Garcia and Alakwa, they first complained about Durand in February or March of 2021. They went to Gina Sardella, the nursing supervisor.
They did. And the response was, frankly, a textbook failure of what's called appropriate remedial action.
It sounds like a classic managerial avoidance technique.
Completely. Sardella holds a meeting with all three of them. When she's confronted, Durand just denies everything. She claims Garcia and Alakwa are lying.
And instead of investigating further...
Instead of investigating the conflicting accounts, Sardella allegedly just ends the matter by telling everybody to get along.
When supervisors are dealing with conflict related to alleged racial animus, telling everyone to get along is legally problematic, isn't it?
It's highly problematic. An employer has an affirmative duty to take prompt and effective remedial action once they are put on notice of harassment.
And that's not it.
Not even close. Simply instructing people to coexist without investigating or imposing any discipline, it suggests the employer basically ratified the hostile conduct. This alleged failure to investigate is a key element supporting the hostile work environment claim against the employer itself.
Because it relates directly to that concept of imputation of liability.
Right. The company is liable because its supervisors failed to act.
And the situation only got worse after Durand returned from pregnancy leave in September 2021.
She allegedly started her hostility again immediately, and there was this pivotal incident around September 2021 when Duran became enraged and screamed at Garcia over some paperwork right in front of patients.
So Garcia and a witness, Cheryl Trent, they complained directly to Barlow, the office manager.
And once again, the management response was allegedly dismissive and passive. Barlow took no action, according to the complaint. It really seems the management philosophy, particularly Barlow's, was just to ignore the problem and hope it would go away.
But the direct racial element became undeniable shortly after that. Garcia and another LPN, Shaniki Chambers, who was Jamaican, they overheard Duran to make two exceptionally ugly statements.
Those statements being, blacks will never amount to anything, and all of the Spanish are illegals.
And this detail is so important because Garcia, identifying as both Hispanic and black, was directly targeted by the substance of those remarks.
Yes. Even if the comments weren't screamed in her face, they contributed to that pervasive, toxic environment.
So Garcia immediately complained to Barlow about these remarks. She noted that Chambers had also heard them.
And Chambers followed up. On October 7, 2021, she sent a detailed email to Barlow reiterating that Duran said black people will never turn out to be anything in life unless they are mixed with white and that all Spanish people are illegal.
So that's explicit written notice to the direct supervisor.
It is. And this date, October 7, 2021, marks a critical pivot in the case. Management has now received formal written notice of specific racial slurs and stereotypes being used in the office. And this is a point the defendants were actually forced to admit receiving in their legal answer, which we'll get to later.
Now we move to the point where the hostility turns into a direct physical threat, also on that same day, October 7th.
Yes. A medical assistant named Sage Herman told Garcia that Durand was making specific and frankly terrifying threats.
What were they?
Durand allegedly stated she was coming for Melissa's blood and that she would take Melissa down with her if she got fired.
So Garcia immediately reports this to Barlow. And she expresses a very specific, credible fear for her safety.
She does. She points out that Durand could potentially access her patient file, which had her home address in it.
To fear for your physical safety at work, especially when a coworker has access to your private information? That's terrifying. How did Barlow respond to a threat that Durand was coming for Melissa's blood?
Allegedly, by completely minimizing the danger and refusing to act. Barlow claimed Durand was all talk and suggested that if Garcia just ignored her, she would go away.
So at this point, Garcia feels she had absolutely no choice but to escalate formally.
Exactly. She emails Barlow, detailing the threats and the racist comments, noting how uncomfortable she felt in this very hostile environment. And then, critically, she forwards that entire email chain to the off-site manager, Maria Alessi.
And by forwarding that detailed complaint to Alessi, she established notice to a higher level of management. She's ticking the necessary legal boxes.
She is. And the immediate outcome for Durand. She resigned on October 18th, 2021, giving 2 weeks' notice.
But the key takeaway from the complaint is that she suffered zero discipline.
None whatsoever. No investigation was launched, and by being allowed to resign with notice, she remained eligible for reemployment within the broader hospital network, which was a specific fear Garcia later raised to Alessi.
So let's pause here and just discuss the legal strategy. The hostile environment claim is what the court calls a single unlawful employment practice.
That's correct. The law recognizes that a hostile work environment is rarely traceable to one specific date or decision. It's the cumulative effect of daily stressors, of abuses, that makes a job intolerable.
It's like water damage, not like a single event.
That's a great way to put it. It's continuous and hard to trace to a single day. Whereas other actions, like a firing or a failed promotion, are like throwing bricks. They are discrete acts with very clear dates.
So when the court looked at this alleged environment, the constant hostility from Durand, the outright slurs from Cyphers, the direct threats, and this sustained failure by supervisors like Sardella and Barlow to take any meaningful action, how did they weigh that mix of direct abuse versus comments that were just overheard?
The court explicitly addressed this. The defense argued that racially hostile acts have to be directed at the plaintiff to count.
But the court didn't buy that.
No. The law acknowledges that harassment directed at coworkers, or things that are simply overheard, can contribute to the overall toxic, hostile environment that the plaintiff subjectively experiences.
Right.
If you are a Black and Hispanic employee, and you hear a colleague stating that Blacks will never amount to anything and all of the Spanish are illegals, those statements land with the same force as if they were directed at you personally. They attack your core identity. They signal that you are unwanted in that workplace.
So the court found the collective weight of these facts was enough to plead the claim.
Absolutely. Sufficient to plead a hostile work environment claim under the law.
And the imputation of liability holding the employers responsible, that rests entirely on management's alleged failure to act.
It does. Westhampton Primary Care and Staff Co. are on the hook because their supervisors, Barlow, Sardella, and Alessi, were put on notice multiple times, starting back in 2020 with the Cyphers complaints and escalating all the way through the Duran threats in 2021.
And their alleged failure to take reasonable remedial action.
Just telling people to get along or being dismissive, that is what links the coworker misconduct directly to the institutional liability.
It's just jarring how quickly the alleged environment shifted from that kind of passive neglect where managers just allowed coworkers to create hostility to active sabotage.
That shift is fundamental.
So let's move to Section 2. Garcia's October 2021 email complaint to Alessi was a protected activity, and immediately after that, the focus shifts to alleged direct supervisory retaliation.
The complaint transitions from documenting a systemic problem to documenting a malicious, continuous, and highly focused campaign perpetrated by the supervisor, Barlow.
And this campaign, according to the plaintiff, was launched immediately after Garcia engaged in that protected activity of complaining formally.
Immediately. Within days. Duran resigned on October 18th, 2021. By October 21st, just 3 days later, Barlow was allegedly soliciting co-workers for negative information she could use as a basis to terminate Garcia.
And the evidence of this solicitation is incredibly strong. One of those co-workers, Sage Hervan, filed a complaint with the union detailing the attempt.
And Hervan's union complaint provides what is probably the most damaging piece of evidence in the entire case. It's direct evidence of retaliatory intent.
So what exactly did Barlow allegedly tell Hervan?
Hervan's complaint quotes Barlow calling Garcia a toxic person in this office and saying they were losing another good employee because of Melissa.
But that's not the worst part.
No. The truly devastating part is what came next. Barlow allegedly asked Hervan directly how they could get rid of Melissa and then pressured Hervan to document it or, astonishingly, to make up something. And the nursing supervisor, Gina Sardella, was allegedly present for this entire conversation.
To suggest or pressure a coworker to make up something, to terminate another employee, that moves so far beyond just pretext. That's intentional malice.
Absolutely. And this fact is a massive strategic advantage for the plaintiff. In a typical discrimination case, the plaintiff has to rely on what's called the McDonnell-Douglas framework.
Which is circumstantial evidence.
It is. You're trying to show the employer's stated reason for termination was just a pretext, an excuse for discrimination. But here, Barlow's alleged statement is direct evidence of retaliatory intent.
So how does that direct evidence shift the burden of proof, legally speaking?
Well, it could simplify the entire case. If the plaintiff can prove that Barlow, the decision-maker, was actively trying to get rid of her and willing to make up something, the court doesn't need to struggle with circumstantial evidence or pretext analysis.
The burden shifts.
Often, yes. It forces the defendant to prove they would have taken the adverse action regardless of the retaliatory motivation, which is an extremely difficult hurdle to clear when you have a quote like make up something on the record. It just turns the entire legal analysis on its head.
So when Garcia and a union rep confronted Barlow about this solicitation, how did she react?
Barlow denied it. She denied ever attempting to solicit negative information, and according to the complaint, she treated the whole matter as a joke.
But she didn't stop.
No, following that confrontation, she allegedly increased her efforts. She instructed the front desk staff to actively monitor Garcia's arrival and departure times and report back to her.
So it illustrates the sustained nature of the alleged campaign. She couldn't get the pretext she wanted, so she switched to active surveillance.
Exactly.
So beyond the attempts to build a termination file, what were the first specific adverse actions Garcia allegedly faced in late October 2021?
Barlow allegedly assigned Garcia to cover all the late shifts that became vacant after Duran left.
And this is important because the complaint states this assignment violated both the internal protocols and the collective bargaining agreement.
Right, which required the most junior medical assistants to cover those shifts. This created, and I'm quoting, tremendous childcare issues and a substantial hardship for Garcia.
But wait, if the union later resolved this issue in Garcia's favor, can she still claim it caused substantial hardship and count it as an adverse action?
Let's take a quick break.
Hey, it's Mark, and we have a new product for you. It's called the Employee Survival Guide. or employeesurvival.com. And it's a site that you can obtain PDF products that I've created myself. I was spending too many hours, way too many, researching and writing about, if, for example, the performance improvement plan or beating them. And the second one about negotiating severance negotiation agreements, two of the most important topics that we see in terms of the web traffic and podcast traffic we have. So check out employeesurvival.com and see if this can try to help you, and you don't need an attorney to use it. Thank you.
That's a sharp question, and it really speaks to the low legal threshold for retaliation. For a retaliation claim, the action doesn't have to be successful or permanent. It just has to be materially adverse.
Meaning it would dissuade a reasonable worker from making a charge of discrimination.
Precisely. The fact that the initial illegal assignment caused tremendous childcare issues and substantial hardship, even if it was eventually corrected, is enough to satisfy that threshold. The harm was felt immediately.
And around the same time, Barlow also allegedly asked Dr. Aponte to monitor Garcia carefully.
Yes, for things like lunch timeliness and cell phone use. This increased scrutiny resulted in Dr. Aponte treating Garcia differently, including yelling at her in front of patients on one occasion.
That's a common subtle form of retaliation, right? The act of monitoring and differential scrutiny?
It is. It signals to the target employee and to their colleagues that they are now under a microscope. And that is certainly behavior that discourages future complaints.
Let's talk about the involvement of the offsite manager, Maria Lessie, because her role is critical for those aiding and abetting claims. What narrative was Barlow presenting to her superior, Alethi, back in October 2021?
It was a narrative that was really calculated to shift the blame onto the victim. On October 20th, Barlow reported to Alessi that Durand quit because of Garcia.
She flipped the script.
Completely. Claiming that two people had now left due to Garcia's toxicity, Barlow specifically asked Alessi if this can be used to counsel Melissa on her behavior. And in that same communication, Barlow dramatically described Garcia's formal complaint to corporate compliance as Barlow being assaulted.
That reframing, turning the alleged victim into the workplace aggressor, is such a clear managerial effort to create a false narrative to justify future action against Garcia.
It shows the alleged campaign didn't stop at the local office level. It was reported up the chain of command to Alessi.
And what did Alessi do?
Well, Alessi did interview Garcia in November 2021 about her complaints, but Garcia alleges Alessi was dismissive. She focused only on the fact that Durand was resigning, implying the problem was solved.
But Garcia voiced her specific concern that since there was no investigation or discipline, Durand was still eligible for rehire in the broader network.
And the complaint alleges Alessi did not conduct further interviews or investigate the substance of Garcia's claims, so she failed to act on Garcia's concern and potentially failed to correct Barlow's false narrative.
The sources indicate Garcia then took disability leave shortly after this, from December 2021 to June 2022.
Yes, she cited exacerbated stress and anxiety from a pre-existing nerve condition, which she claimed was due to the discrimination and retaliation.
But when she returned in June 2022, the alleged retaliation didn't stop.
No, it entered the phase that was definitively timely for the court to consider for federal law purposes.
Okay, so post-leave, the actions are distinctly linked to that timely period.
And they continue the thread of Barlow's alleged intent to get rid of Garcia. Shortly after her return in June 2022, Barlow allegedly went out of her way to try and blame Garcia for an incident where a worker incorrectly told a patient they had a positive COVID test result.
Even if Garcia was only tangentially involved, this attempt to fault her fits perfectly with the established pattern of trying to build a file.
It does. And then in July 2022, Barlow allegedly engaged in a highly specific action to block Garcia's career progression.
This is a textbook discrete adverse action. Failure to promote.
Absolutely. Garcia had applied for a care coordinator position and was, according to the complaint, the only applicant. Knowing this, Barlow allegedly tried to solicit several more senior employees to apply, explicitly trying to block Garcia's promotion opportunity.
That's a crucial, timely act of retaliation and a very concrete injury.
It is. And finally, in March 2023, there's the incident involving another LPN, Michelle Derma.
Right. What happened there?
Derma asked Garcia for advice on how to handle a racial discrimination situation, the very type of protected activity Garcia was being targeted for. When Barlow found out Derma had spoken with Garcia about this, Barlow allegedly demanded that Derma stop speaking with Garcia entirely.
Both at work and outside of work.
Yes, it's an attempt to silence and isolate the complainant, preventing her from advising other employees on their protected rights. A chilling way to cap off the alleged campaign.
So if we connect this all back to the bigger picture, the entire narrative documents this evolution of the alleged adverse action.
It moves from overt shift changes, which were quickly fixed by the union, to continuous monitoring and these more subtle but profound acts like blaming, blocking a promotion, and instructing coworkers to shun her.
And it's this continuous line of malicious conduct that the court used to save the retaliation claims from being blocked by the time bar, which leads us directly to Section 3. The defendant's legal responses and their affirmative defenses. The fact that the institutional defendant, Westhampton Primary Care, and the other defendants filed two separate answers, that's already telling, isn't it?
It is, because it reflects two very different legal strategic positions. Westhampton Primary Care is represented by the Attorney General of the state of New York,
Which reflects its affiliation with Stony Brook University Hospital, a state entity.
Right. And the other three staff co and the individual managers, they're represented by separate private counsel.
So starting with Westhampton Primary Care's answer, the state entity, they essentially denied having sufficient knowledge of anything that happened.
They did. Their answer relies on denying knowledge or information sufficient to form a belief regarding almost all of the factual allegations.
Everything from the cipher slurs to Duran's hostility to Barlow's solicitation.
All of it. This is a common strategy when a major institution claims the day-to-day operations were handled by lower-level managers or the PEO. It's an attempt to minimize their direct culpability.
But amid all those denials, they made one extremely important admission about the employment structure.
Yes, WPC explicitly admits that Staff Co. hired the plaintiff and is responsible for all personnel matters related to their employees, including the plaintiff.
Which reinforces the plaintiff's core legal argument that they are joint employers.
It does. It means WPC can't simply say, oh, that's Staff Co.'s job, and walk away entirely.
So what were Westhampton Primary Care's most powerful affirmative defenses?
The jurisdictional defense is the biggest one. They argued that the claims against them under the New York State human rights law are barred by absolute immunity under the 11th Amendment to the U.S. Constitution.
The 11th Amendment. For listeners less familiar with constitutional law, why is this such a powerful state-level defense in a civil rights case?
Well, the 11th Amendment grants states what's called sovereign immunity. It means states generally cannot be sued in federal court by their own citizens unless they consent.
And WPC is asserting this immunity because of its affiliation with Stony Brook, which is part of the state university system.
Exactly. They are arguing, we are an arm of the state, and you cannot sue the state of New York for claims arising under state law in federal court.
That's a massive legal shield. Does that shield apply to the federal Title VII claims?
No, it doesn't. Title VII claims generally override state sovereign immunity because Congress explicitly abrogated that immunity when it passed the law. But if the court had agreed with WPC on the 11th Amendment defense, it would have knocked out all the NYSHRL claims against them.
Which would have dramatically narrowed the scope of their liability.
It would have.
WPC also asserted they had no notice of the alleged discriminatory or retaliatory acts.
Which, as we've discussed, directly contradicts the plaintiff's timeline of repeated supervisory notifications. And then they threw in the standard defenses. Failure to state a claim, failure to establish a violation. It was really a wall of procedural and jurisdictional defenses.
Okay, now let's look at the answer from Staff Co., Barlow, and Alessi, represented by private counsel. Did they follow that same strategy?
They took a slightly different tack. While they denied the majority of the factual allegations, their answer contains some specific, verifiable admissions.
For instance, they admit Staff Co. advises and oversees HR at WPC, reinforcing that PEO status.
And crucially, Barlow admits receiving Shinneki Chambers' explicit email on October 7, 2021, regarding Duran's racist comments.
So this group of defendants, they can't credibly argue a lack of notice regarding the race complaints. That weakens their ability to rely solely on the failure to provide notice defense.
Correct. They also admitted Garcia sent the follow-up hostile environment and threats email to Barlow and Alessi on October 7th. They admitted Barlow sent Alessi an email about Durand on October 20th.
But they deny the malicious substance of that email.
Right. They deny the characterization of Garcia as toxic or Barlow asking how to counsel her. So they're admitting the paper trail exists, but denying the specific retaliatory intent behind those documents.
And in terms of their affirmative defenses, Stafco and the individuals, they concentrated on the merits of the case rather than jurisdiction.
They did. They focused heavily on challenging the legal sufficiency of the plaintiff's case, arguing failure to state a prima facie case for discrimination or retaliation.
Specifically claiming there was no materially adverse action, no causal connection between the complaint and the actions.
And that the environment wasn't truly hostile. And critically for the individual managers, Barlow and Alessi, they asserted that they cannot be held liable for aiding and abetting under the state law because they did not aid, incite, or coerce any wrongful conduct.
They're preemptively challenging that secondary liability claim.
Exactly.
So we have two different sets of denials, two different sets of defenses. One focuses on state immunity, the other on challenging the merits.
Which leads us directly to Section 4, the court's legal analysis and its initial ruling on the motions to dismiss.
In the motion to dismiss Rule 12b-6, it's purely a procedural gatekeeper.
Oh, it is. The court has to accept the factual allegations in the complaint as true, including the slurs, the threats, and that make up something, quote.
And then it just determines if those facts, if they were proven, would support a legal claim.
Right. The court isn't deciding if Garcia wins, only if her claims are legally sufficient to move forward into discovery.
So let's start with the immediate dismissals. The disparate treatment claims were quickly dismissed.
They were. The court found Garcia had essentially forfeited any arguments for disparate treatment by not addressing them in her opposition brief. But even so, the court also ruled that the complaint failed to plead sufficient facts showing she suffered adverse actions because of her race outside of the hostile work environment claim.
Because most of the negative actions alleged, the monitoring, the shift changes, the promotion block, they were all explicitly alleged to be retaliation for complaining.
Exactly. Not primary race discrimination because she is Black and Hispanic.
Now, for the claims that survived, the hostile work environment, or HWE claims, the biggest hurdle here was timeliness. Explain again how the continuing violation doctrine was the legal lifeline for this claim.
So the Title VII filing deadline, it cuts off claims for discrete acts that happened before December 9th, 2021. The continuing violation doctrine is the big exception for HWE claims. And the court found that this entire 4-year span of incidents constituted a single unlawful employment practice.
A continuously hostile work environment.
Right.
So what made the court connect the dots between the 2019 racial slurs and the 2023 attempts to isolate Garcia? I mean, the nature of the misconduct seems to have evolved so dramatically.
It did evolve, but the court found they were sufficiently related. And the court's logic here was really compelling.
What was it?
Okay, so first, similar nature. The harassment moved from coworker racial hostility, which was pre-deadline, to supervisory malice and retaliation, which was post-deadline. The connection is that the retaliation was punishment for complaining about the initial racial hostility.
Okay, that makes sense.
Second, the same perpetrator over time. Barlow, the alleged primary retaliator, she perpetrated conduct both before the December 2021 deadline and after. Her consistent involvement provides the glue that holds it all together.
And the final point.
Employer failure to act. The employer's alleged failure to take appropriate remedial action throughout the entire period, starting with ciphers and continuing right through Durand, links the early acts of hostility to the later sustaining of the environment.
So by applying this doctrine, the court essentially chained all 4 years of alleged hostility together. It allowed all the HWE facts from the 2019 slurs to the 2023 shunning to be considered for liability under Title VII.
It preserved the core narrative, and on the merits, the court found the alleged conduct, the racial slurs, the physical threats like coming for my blood, and the managerial campaign that followed was sufficiently severe and pervasive.
Okay, so moving to the retaliation claims. The court agreed Garcia engaged in protected activity and that the collective adverse actions could plausibly dissuade a reasonable worker. But here, the timeliness slicing was handled differently.
And this is the critical technical distinction. The continuing violation doctrine generally does not apply to discrete unlawful acts.
Like a firing, a failure to promote, a specific suspension.
Right. Those are like the bricks we talked about. Each one starts its own 300-day clock.
Which means some specific acts of retaliation were dismissed as untimely under Title VII, even though the overall hostile environment claim survived. So which specific acts were chopped out?
Duran's physical threat and the failure to discipline Duran, both from October 2021, were dismissed as untimely, discrete acts under Title VII.
And the key legal reason for that dismissal?
It was that these acts involved Duran, a different actor than the management, specifically Barlow, who was conducting the timely retaliation. Since they weren't linked by the same supervisor's direct retaliatory intent, they were seen as discrete and outside that 300-day window.
So the court drew a really fine line. If the adverse action was part of Barlow's alleged continuous campaign to get rid of Garcia, it was saved.
Yeah.
But if it involved a failure to act against Duran, it was dismissed as a separate, untimely event.
Exactly. However, Barlow's continuous actions to get rid of Garcia, starting right after the complaint in October 2021, those were saved. The court linked the pre-deadline acts, like the shift assignment and monitoring, through retaliatory intent and temporal proximity to the timely acts, like the COVID test blame and the promotion block.
So the court found that this pattern of conduct, all driven by the same supervisor with the same stated objective, get rid of Melissa, could be viewed as a single, continuous retaliatory course of conduct.
Correct. And that saved the retaliation claim against the employers.
This brings us to the final and really fascinating legal slicing. The distinction between primary liability and secondary liability for the individual managers, Barlow and Alessi.
Right. So primary liability means you are directly an employer under the statute. And the primary liability claims against Barlow and Alessi under Title VII were dismissed.
Why was that?
Because the complaint failed to allege facts that they controlled hiring, firing, or compensation. Title VII doesn't generally permit primary liability against individual employees who aren't statutory employers.
So Garcia had to rely heavily on the secondary liability claims using the state law's powerful aiding and abetting provision.
And this is where the detailed allegations about Barlow's behavior really paid off. The court found her alleged actions soliciting negative feedback, the illegal shift reassignment, the active monitoring, the attempt to block the promotion, all of that plausibly constituted actual participation in the unlawful conduct.
So the aiding and abetting claims for both HWE and retaliation survive against Maria Barlow. She stays in the lawsuit as a defendant.
She does.
But what about Alessi, the offsite manager? Her involvement was less direct. She was a recipient of complaints and the one Barlow reported to.
Her outcome was split, which gives us a great insight into the limits of aiding and abetting liability. The HWE aiding and abetting claim survives against Alessi.
And the reasoning there.
The court reasoned that Alessi actually participated in sustaining the hostile environment by failing to investigate Garcia's repeated complaints, by being dismissive, and by failing to properly address the risks posed by Durand. Her inaction, when she was put on notice, was deemed participation in maintaining that hostile environment.
But the retaliation claim against Alessi was dismissed. Why was that distinction made between HWE and retaliation participation?
Because the retaliation aiding and abetting claim was dismissed. The court found the complaint failed to allege that Alessi was sufficiently aware of Barlow's specific retaliatory actions, the internal solicitation, the promotion block, the instruction to Derma, and so on.
So if she wasn't aware of Barlow's underlying unlawful retaliatory conduct, she couldn't plausibly have aided and abetted it.
Exactly. Her mere dismissal of the initial race complaint was enough to sustain the HWE claim, but it wasn't enough to tie her into the ongoing active retaliatory campaign.
That is a fine distinction, but a crucial one. Inaction after notice supports the HWE claim, but aiding and abetting retaliation requires awareness and participation in the specific acts of retaliation.
Precisely. And this outcome significantly preserves the lawsuit. Melissa Garcia's case moves forward against the institutional defendants, Westhampton Primary Care and Staffco, based on both the sustained hostile work environment and the continuous retaliation.
And the individual manager, Barlow, is also still in the case, facing secondary liability for aiding and abetting both HWE and retaliation. Alessi remains only for HWE aiding and abetting.
That's the state of play.
This deep dive gives us such a fascinating look, not just at allegations of egregious workplace conduct, the slurs, the physical threats, the outright managerial malice, but also at the legal framework required to make those allegations stick across years of evolving misconduct.
And specifically how the plaintiffs strategically used the continuity of the alleged supervisory malice, which was driven by that direct evidence of retaliatory intent, to save the entire historical narrative from being dismissed as time-barred.
So a final takeaway question for you, the listener. The court noted that Barlow's alleged statements to Hervin about needing to get rid of Garcia were direct evidence of retaliatory intent. How does the specific detail, an internal conversation between managers, shift the burden of proof compared to relying solely on the timing of adverse actions? If Garcia can prove Barlow really said make up something, does that effectively end the defendant's case and leave only the question of damages? It's something to mull over as this case now moves toward the discovery phase.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.